हेलो एवरीवन, वेलकम टू जुरिसेज एकेडमी। आज के वीडियो में बात करेंगे रिजर्वेशन के बारे में। नाउ रिजर्वेशन इज बेसिकली गिवन टू द मार्जिनलाइज्ड सेक्टर टू ब्रिंग देम बैक टू द मेन स्ट्रीम। नाउ अगर रिजर्वेशन 100% दिया जाए मार्जिनलाइज्ड सेक्टर को, तब क्या बोला जाएगा? नाउ इन दिस वीडियो टुडे वी विल टॉक अबाउट दिस पर्टिकुलर इशू इन रिलेशन टू वन रीसेंट जजमेंट दैट हैज बीन प्रोनाउंस्ड बाय द सुप्रीम कोर्ट। सो लेट्स टॉक अबाउट इट and let's start the video. Now before starting the video, I need to tell you about two things. The first is the Telegram channel. Have you subscribed to it? Not. The reason being, every day hundreds of students are participating in the quiz, so do subscribe to it. And the second thing, we have just recently launched one CLAT PG 2023 capsule course, which is very helpful, precise, hardcore material, softcore material, live lectures, mocks, live mock analysis, everything is included. And it's very affordable. Students are loving it. So if you haven't checked the course, kindly do check it. The link is given below in the description. Now let's start with the case. Now first is why we are talking about this case. Now recently Supreme Court has basically struck down 100% reservation in the case of Satyajit Kumar versus State of Jharkhand. That's why we are talking about this case. Now let's know more about the facts of this case. Now in 2016 State of Jharkhand has issued one notification. उस notification basically 13 scheduled district के लिए था, जहां पर उस 13 scheduled district के local resident will only be able and eligible for the district cadre class 3 and class 4 job. Now उसी notification को मानते हुए एक एडवर्टाइजमेंट निकला, जॉब वैकेंसी निकली, और जॉब वैकेंसी में ये भी बोला गया कि उस 13 शेड्यूल डिस्ट्रिक्ट के लिए सिर्फ लोकल रेजिडेंट अप्लाई कर पाएंगे, सिलेक्ट होंगे, एप्लीकेबल होंगे, बाकी नॉन शेड्यूल रेजिडेंट के लिए वो नहीं है, एंड दे आर नॉट एलिजिबल फॉर दैट 13 शेड्यूल डिस्ट्रिक्ट पोस्ट। नाउ इन दिस केस नॉन शेड्यूल रेजिडेंट अप्रोच द कोर्ट, स्पेशली हाई कोर्ट, चैलेंजिंग दिस पर्टिकुलर नोटिफिकेशन. And they did that, and High Court basically struck down the notification by saying and folding the case Chebrulurila Prasad and said that 100% reservation is invalid. It's constitutionally invalid in relation to or in contravention of Article 14 and 16, which is absolutely right as per the understanding of Chebrulurila Prasad. Now, what is the problem that we have at our hand? Let's get into that. Let's understand this case more. Now, sir, आप तो बहुत कुछ बोले हो. What is the problem, sir? The problem is, look at the paragraph 5 of the Schedule 5. Now, here is the paragraph 5, Schedule 5. Now, if you start the seeing or understanding this paragraph 5, Schedule 5, it is starting with the Non-Obstetric Laws, and you can understand as a law student what is the meaning of Non-Obstetric Laws, what is the importance of Non-Obstetric Laws. It has the power to override any of the provision in the constitution. So that's one thing. Second thing, under this particular paragraph, governor has the power to modify laws or probably enact laws or not. Lot of questions were asked. Now this particular paragraph, why this is important? Because under this paragraph the notification was issued by the State of Jharkhand, जिसमें लोकल रेजिडेंट को सिर्फ एलिजिबल किया गया था 13 शेड्यूल डिस्ट्रिक्ट में. ना अभी सवाल ये उठ रहा है कि इस पैराग्राफ 5 का क्या इतना पावर गवर्नर को देता है कि गवर्नर कैन मेक 100% रिजर्वेशन इन शेड्यूल डिस्ट्रिक्ट और नॉट, और अगर कर भी सकता है तो कैन इट ओवरराइड द फंडामेंटल राइट्स, पार्ट 3 ऑफ द कॉन्स्टिट्यूशन? That's another question. So this is the problem that we are going to face. Now by saying that, let's get into the issues. The issue I have already discussed. Now let's frame it better. Now first is whether the paragraph 5 and Schedule 5 confers the power to governor of 100% reservation, and also by that which is in contrary to Part 3 of the Indian Constitution. And the second issue that was going to be there under paragraph 5, Schedule 5, can governor modify the rules under Article 309 of the Indian Constitution? So these are the two issues that were there. Now let's get into the court's reasoning, what the court has said while striking down the 100% reservation. Now, in the court reasoning, I am going to divide this whole court's reasoning into two parts. The first, definitely talking about the governor's power, the scope of the governor's power under paragraph 5 of the Schedule 5. And the second part, I am going to talk about the 100% reservation. Now, first, let's talk about the paragraph 5, Schedule 5 and the governor's power to make laws or not, and a lot of things, the scope of governor's power under paragraph 5, Schedule 5. Now, in the court's reasoning, the first and foremost thing, Supreme Court got into the High Court's judgment. And while getting into the High Court judgment, they got introduced with the judgment of Chebulu Lila Prasad. Now, Supreme Court also rightly quoting the Chebulu Lila Prasad said the facts are more or less similar, which that we can see right now in this case with the Chebulu Lila Prasad, and that's why Chebulu Lila Prasad can be quoted here. And by observing the Chebulu Lila Prasad, the court said the power has been described elaborately there in that case, Chebulu Lila Prasad के केस में, और वहां पर बोला गया है कि first the governor cannot enact any new law. It is not giving any subordinate legislation power to governor. It can only apply or modify the law under paragraph 5, Schedule 5. The second very important thing, the under paragraph 5, how much power it has been given to the governor. Now in that case, in Chebulu Lila Prasad, it has been held that the power that has been given, that is, or the governor's power is in pari passu with the, is working side by side. Governor's power is same like the legislative power of the state and parliament. So as the legislative power of the state and parliament is basically subject to the fundamental rights and the part 3 of the Indian Constitution, and that's why governor's power under paragraph 5, Schedule 5 is also subject to the part 3 of the Indian Constitution. Having said that, the power that has been conferred under the paragraph 5 cannot be the arbitrary one. Governor has to act reasonably under this paragraph. So this has been held by the Chebulu Lila Prasad. Another very important discussion that Chebulu Lila Prasad had, its relation to non-obstetric laws. Sir, ye to scope of power I can understand. But what about the non-obstetric laws that has been mentioned? Now, why the non-obstetric laws? What is the scope and the periphery of the non-obstetric laws? In regards to that, Chebulu Lila Prasad said the non-obstetric laws that has been mentioned is in relation to Article 244 and 245, not in relation to whole Constitution or the basic structure of the Constitution. As the governor can modify and apply any law, it can also modify, apply any parliament law. And Article 244 and 245 has given exclusive power to parliament and also the state that can be modified by the governor under this paragraph 5. That's why this non-obstetric laws has been used. Having said that, now we can very well understand how the governor's power is very much limited and curtailed under the paragraph 5 and Schedule 5, as it has been discussed by the Chebulu Lila Prasad. Now let's move on to the next part of the court's reasoning, that is 100% reservation. Now 100% reservation के मामले में सबसे important चीज है कि आप लोग इंदिरा साहनी के बारे में जानते हो. I don't need to tell you. And after the Indira Sahani, one very important fact and the cap of the reservation that has been held, that is 50%. Though there is some exception in relation to 50% reservation, but in that case, far-flung state, different taste that has been laid down in the Indira Sahani that has to be considered. Now, having said that, can 100% reservation has been given? In Indira Sahani it has been said, and also Article 14 and 16 में ये भी बोला गया है 100% reservation cannot be given. It is wholly indiscriminatory. It's wholly discriminatory in nature. Okay, so that's why it cannot be given, and 100% reservation has to be struck down, and governor cannot do that under paragraph 5, Schedule 5. Now, coming to the next point, can governor modify the rules under Article 309? In that case, one very important thing, the rule under the Article 309 are not the acts or the laws or enactment. So in that case, those rules cannot be modified by the governor. So that part is also given solution by the court. So this is all from my side in relation to this. And finally, the court struck down the 100% reservation by quoting the Chebrulu Lila Prasad. So people who are going for different exam, please do give it a watch or reading the Chebrulu Lila Prasad case, which is important in relation to this case. Okay. So this is from my side regarding this case. If you like the video, give it a thumbs up and don't forget to subscribe to the channel. And also don't forget to subscribe to the Telegram channel. And don't forget to check the course that we have just recently launched. It's very helpful, affordable, comprehensive, and smart and precise. So thank you. See you in the next video.